Greetings, tort scholars. Previous reviews set forth the elements of several intentional torts, including assault, battery, and false imprisonment. To recover for an intentional tort, as for any tort, the plaintiff must prove all the elements of that tort. She must, quote, make a prima facie case, unquote. That is, submit credible evidence on each element that the law requires in order to recover for the tort. If the plaintiff does make a prima facie case, however, the defendant may still raise various affirmative defenses. That is, introduce other facts that will avoid liability even though the plaintiff proves the elements of the tort. One common affirmative defense is the statute of limitations. Defendant asserts that even if you prove that I battered you, the 2-year limitations period for battery has passed, so you can't recover anyway. Another common affirmative defense, covered in a separate Practice Perfect review, is self-defense. Well, if I did sock you in the nose, it was because you were assaulting me, and I was defending myself from your assault. This review addresses another affirmative defense to intentional torts, consent. Tort law takes the position that a party who accepts a tortious invasion cannot later turn around and sue for damages for it. Having chosen to accept a contact, you have no complaint. Suppose, for example, that Moe and Curly are rehearsing for a movie, and Moe pokes Curly with his fingers as part of the gag. Here, Curly, by taking the role, knowing of the gags involved, agrees to a touching that would otherwise be an offensive contact. He has consented to it, and that will bar him from recovering damages for the contact. Or suppose that Matilda and Rhonda agree to engage in a shoving match to see who can knock the other down. Matilda pushes first and then Rhonda pushes back. But Matilda stumbles backwards and falls, suffering an injury. Because Matilda consented to the shoving, she would not be able to recover from Rhonda for her injury. Here too, the parties have agreed to accept contacts that would otherwise be batteries for their own reasons. We should note here that it's not entirely clear whether consent is an affirmative defense to an intentional tort, or, on the other hand, whether lack of consent must be pled and proved by the plaintiff as an element of the intentional tort. A good many courts place the burden on the plaintiff to allege and prove that she did not consent to the contact, but other courts treat it as an affirmative defense. The most obvious type of consent would be consent in writing to an expected contact. Perhaps the producers of a play that features a sword fight ask the actors to sign a form, consenting to the contacts that take place in the fight scene. But a person clearly can consent to a contact by conduct as well as by explicit agreement. In a famous case on consent, O'Brien versus the Cunard Steamship Company, O'Brien was an immigrant and found herself in a line of women receiving vaccinations before landing in Boston. She stood in line, and when she reached the doctor, she held up her arm. The doctor proceeded to vaccinate her, although she had never said that she consented to the shot. Later, she got sick from the injection and sued for battery. The doctor defended on the ground that O'Brien had consented to the vaccination, and the court held that O'Brien's conduct at the time reasonably manifested consent to the doctor, so he was not liable for battery. The third restatement accepts this concept of apparent consent. It provides, quote, apparent consent exists if the actor reasonably believes that the other person actually consents to the conduct, without regard to whether the person does actually consent. Whatever O'Brien may have been thinking as she held up her arm, her conduct reasonably looked like consent, and the doctor was entitled to rely on the reasonable appearance of consent, whether the passenger really wanted the shot or not. We all act at times on the reasonable appearance that a contact will be welcome in particular circumstances, perhaps in hugging a person who you meet for the first time at a party, or in roughhousing at an athletic practice. It's also clear that a person may consent to one contact without accepting another. The fact that a person on a date appears receptive to a kiss in the moonlight does not reasonably convey agreement to more intimate sexual advances. Similarly, consent to a shoving match would not reasonably be construed as consent to a battle with knives or brass knuckles. Such examples raise the question of the scope of consent. That is, the victim may have consented to some contact, but not necessarily to the contact she actually experienced. Suppose that a person consents to a contact, but suffers an unexpected injury as a result. Jenks, a patron in a bar, consents to a shoving match with Rios. They give a few shoves back and forth, and one shove by Rios causes Jenks to fall backwards and hit his head on a bar rail, suffering a serious concussion. Jenks consented to a shove, but he didn't consent to a concussion, did he? Shouldn't Rios be liable for the unwanted concussion? Well, because the contact that Rios made, the shove, was consented to, it was not a battery. And so the consequence of the shove, hitting the bar rail, is a consequence of a non-tortious touching. But suppose that Jenks and Rios had consented to light shoves back and forth, and Rios gave Jenks a humongous heave. Rios should probably understand that this exceeds the scope of the contact that Jenks had agreed to, so this contact may exceed the scope of consent, making Rios liable if a concussion results. For consent to be meaningful, the party who consents must understand the true nature of the contact that the other party has offered. Suppose that Goliath offers his enemy David an open box of chocolates. David takes one out and eats it, only to discover that it is full of hot pepper, which burns his mouth. Here, it was clear from the circumstances that David meant to consent to contact with an ordinary chocolate, not one laced with hot pepper. So David's consent is not genuine. It is negated by his misunderstanding of the nature of the contact. The contact that Goliath knew he was offering, a hot pepper chocolate, was entirely different from the contact that David was agreeing to. And Goliath knew that David fundamentally misunderstood the nature of the offered contact. Another example of this type of invalid consent involves a party who invites sexual contact without revealing that she has a venereal disease. In this situation, the consenting party has one understanding of the contact consented to, but the offering party knows a fundamental fact about the interaction that the consenting party does not, and which would lead the recipient to refuse consent if she knew. Due to this misunderstanding, the consent is ineffective, so the contact will constitute battery. Consent issues often arise in cases of medical treatment. A healthcare practitioner must ordinarily have the patient's consent to any type of invasive treatment. In one of the classic intentional tort cases, Moore v. Williams, the patient consented to an operation on one ear. Once the patient was under anesthesia, the doctor decided the other ear was worse and operated on that. The court held that this constituted battery because the patient had not consented to the procedure that the doctor performed, even though the operation was successful and done with the best of motives. The doctor invaded the plaintiff's person without consent, a highly offensive contact. Of course, there may be difficult questions about the scope of consent in medical cases. Suppose that Arden consents to an exploratory operation on her colon to determine why she's having pain. When the surgeon opens Arden up, she discovers a tumor on Arden's colon and removes part of the colon. This again is an issue of the scope of consent. What would the parties reasonably have understood that Arden was agreeing to when she consented to the operation? At least some minor extensions of surgery in the affected area would presumably be encompassed within a general consent to surgery. The third restatement offers the example of consent to a 3-inch incision, but circumstances required that it be 5 inches. The restatement suggests that this minor deviation from consent, in order to accomplish the procedure that the patient expected, would not vitiate the plaintiff's consent. But it could be a close question whether removal of part of the colon was within the scope of Arden's consent to exploratory surgery. Another common consent issue arises if an injured party is unconscious, so they cannot consent to medical treatment. It may be necessary to provide treatment immediately before the patient recovers consciousness. It's probably best to think of these cases not as consent cases, but as emergency privilege cases. Will the law recognize a medical practitioner's right to provide life-saving treatment without the consent of the patient, because the treatment must be rendered immediately? One solution in these cases is to obtain consent from a close relative or from a person who holds a healthcare proxy to consent on behalf of the injured party. But if no one is available to give a substituted consent, most courts will recognize the right to proceed with medical treatment if three things are true. First, that the treatment must be rendered immediately, that it is not feasible to wait until the patient becomes conscious, and get an express consent. Second, that the treatment is essential to the life or health of the patient. And third, that the practitioner has no reason to believe that the particular patient would not accept the treatment. Battery law protects an individual's personal right to choose. A doctor would commit battery if she provided treatment, even life-saving treatment, knowing that the patient does not accept it. This situation arises most frequently with patients who refuse various types of treatment based on religious objections. The need to render emergency care might also arise in cases where there's no healthcare provider available.
Yeah, okay, that's fine.
For example, Florio might come upon an accident on a rural highway where no one else is around and realize that Wilkins, the party injured, requires cardiopulmonary resuscitation. Very likely a court would recognize a privilege for Florio to perform CPR here, if he knows how to do it. After all, if we could ask Wilkins in this circumstance, he would almost certainly consent to CPR. So according to privilege, we'll usually effectuate the choice that the injured party would have made if he could have been asked. The draft third restatement of torts does not confine the emergency privilege to medical providers. It would allow the privilege to Florio as long as the three prerequisites for its application are met. To further your understanding of these interesting issues, have a go at our Practice Perfect quiz on consent.